Thank you very much, Bertrand. It was great. We gained lots of information. So whenever you speak about the role of politics, how to find the role for the national parliament in the European construction. Yes, the parliaments have to deal with the harmonization issues and so on. So it is also a question of harmonization. Yes, I know, but don't you think that national parliaments have got some role to find solutions? So I saw that in the European Parliament, national parliaments have no role at all to design European politics. So how to find an equilibrium between member states? Can it be imagined?
Alors, je crois que c'est en effet.
I do think that it is one of the questions which is one of the most important ones. Well, we've got the European construction, which reinforced executive powers. And in France, this is not a real problem because in France we've got this kind of tradition. The executive power has always been very strong. But for other countries, this is an issue. And there are some rules which are not used. For example, national parliaments could have proceedings against the European Parliament whenever they don't comply with its decisions. But there is also a controversial and very difficult question. Would it not be important to have representatives of national parliaments in the European Parliament, giving directly the possibility, how to say it, to speak about certain questions? So I think that we should have a border framework. So we do not have a real European politics. So parliaments in the states are elected based on national interests. So how to have a European Parliament whenever we do not have common interests? So it's a big question. What power to give to the European Parliament? What I'm afraid of for France is that there is no interest for our French parliament members for European issues. So French PMs are interested by French issues and they do not deal with the European ones. And we all the time think in France that that's okay. You can have the EU, you can have this empire feeling in EU, but France is France and we will overcome all these issues. So there is no interest among French PMs to this question. But the Court of Justice and the Commission, these are very strong bodies. So we've got the judicial power, we've got executive power, but and they've got power, but legislative power to the European Parliament, well, it's not that harmonized. So we have to find a solution at this level.
Je voudrais aussi poser ma question.
I would like to ask a question in French. I would like to ask a question to Professor Bertrand Mathieu. I really liked your presentation and thank you very much for your proposal. And there were some very, very strong sentences. So we should really reflect on what you've just told us. I'm not sure that I completely noted everything, but we should have the people having laws and not laws generating people. So what is that is why I would like to ask the same question: what is the role of national parliaments and the civil participation? Would it not be something very important in this sense? And NGOs, you said they are not transparent, even if they have a very important force or power now, and they can attack and so on. That's what you said, that they lack transparency. So if we give the right to the demos, to the people, the participation of NGOs or civil participation could also be reinforced parallelly, because I had an impression that you gave us, so you put a stronger accent on central power, but if you say that the decisions should are the, so you say that this is the Commission which decides. So we should have a preliminary consultation also with the people and impact studies. Should we not have this kind of mechanism? I would like to have your insight on the results of the conference on the future of the Union, for example. What do you think about it? Because there was a long consultation proceedings in order to talk with European citizens. So could it work? This kind of proceedings, could it work? So could we not integrate more the civil part in the functioning of the EU? How could we make citizens participate more? Thank you very much. All right. Oh, I am so happy because I'm not the only one speaking French, so thank you so much. So I would like to ask a question, a very important question, and I do not have the solution for it. So why there is this question? The democracy, representative democracy in numbers of states and in Europe, it is sick. And as it is sick, where is the solution? We seek for other solutions. We seek for example, participative democracy. But there is a problem, because it can be one of the possibilities, but there are several limitations, obstacles. In the participative democracy, what is the core question? We've got several questions, but there is one core question. Whenever you consult, for example, on the question of euthanasia, who will participate? Associations for the euthanasia and against euthanasia. So this is a process. I do not say that it is bad, but nowadays it is elitist. We've got some organizations, bodies of representation of interests. It's never ever the citizen who participates whenever it is participative democracy. And there is another question. Democracy, the participative democracy, it was an expert field. I used to work on the bioethical questions. And whenever it comes to, for example, of a question of embryo, whenever you show 3 cells, you say, oh, that's okay. But whenever you have a bigger embryo, oh, it's horrible, but it is manipulation. So experts can manipulate. So there is manipulation, which is the second obstacle, and there is a third one. Namely, what happens if we are drawing of lots, if we just decide arbitrarily. Who makes the choice? In the democracy, you have the choice between opinions, projects. And if you do not have this choice because there is a draw, well, I do not think, but this is only my opinion, and as it is mine, it's not the only existing possible. I am sure that we are not ready now in Europe to have a participative democracy. So the only question is that I think this only participative question is will we have what kind of time will we have the winter one or the summer one. But it is a very simple question, and everybody could have an opinion. Would we like to have a 1 hour plus or less to sleep? You do not have experts to decide. But even for this question, we were not able to decide. So these are limitations of the participative democracy. And if you want to have participation, you need more transparency. Financing, for example, representation, for example. In the Venice Commission, whenever we go to a country, we meet several people, we talk to MPs and ministers, and we are told the civil society told, but who is a civil society? I was all the time shocked, because whenever you ask X, they will say something. Whenever you ask why, it will say something else. That's it.
I would like to first to mention the example of medieval Serbia and the Svetisava Nomocanon. As you probably know, that code was enacted and redacted at the beginning of the 13th century by Svetisava, and it was influenced by Byzantine and Roman law. And as it was explained by Žarko Vidović, there was that Roman principle of interdependence and separation between state power and the church that were inscindibly connected, but however they were separate. But on the other hand, the whole system was not based on the principle of universality as in the Catholic world, but it was rather particular, applying only to that specific state, to Serbia. What do you think? Can it be considered some kind of union or conjunction between the Roman principle and the Westphal system, at least in the light of that Latin locution, cuius regio eius religio?
So thank you for the question. This cuius regio eius religio, from my point of view, does not belong to the Roman heritage. It's a strictly Westphalian version. Of course, there is a strong, and there are a lot of strong differences between the western and eastern part of the Roman Empire, but at least until the 13th, 14th centuries, the primacy of the Patriarch of Constantinople, Patriarch of Nicaea, so his primacy was very, very close to the primacy of the Roman Pope. Even if later the local authorities of the Orthodox churches became stronger and stronger. Now we have the autokephalia version that if the Synod of the Oriental churches accepts a kind of sovereignty of the churches of the different states, then they are different. But we still see that there is this problem, for instance, with the Church of Ukraine. Because practically, yes, we have the nominal primacy of the Patriarch of Constantinople, but the strongest patriarch is the Patriarch of Moscow. So this is a question, an internal question of the Orthodox churches. We may enter in these details, but what I tried to point out, it was not this detailed difference between East and West, but the most general approach. And the most general approach was that and we see the same in Serbia, we see the same in Romania, we saw the same during the Russian Empire, before the communism, that the patriarch was still very strong. And we see the same in the case of Georgia, because practically, even if it is not included in the constitution, if I'm not very wrong, then the Patriarch of Georgia has even now a very important vote in the main changes in the country. So this is what remained from the Byzantine culture. Even if it's different, of course, it's different from West, because the difference comes with the time when the Western Roman Empire was falling down. So it became very, very quickly after the Christian culture became general in Europe. So practically it was parallel.
And maybe, as Professor Mathieu put it, the most important thing is that we talk about the right questions, even if we might disagree. So I would like to point to some of the provocations that I felt and make them explicit so as to help us address the question, maybe. First thing I learned, which I liked a lot, the sun is going to rise even after sovereignty is gone. A provocative answer, I agree, but, and that's also for a colleague from Poland, Professor Muszyński, I think sovereignty probably has always been a fiction, a legal artifact, as so many out there. Also that one we learned this morning, the inventive power of lawyers. It might be less credible and forceful today, but it has never been more than a legal artifact. So maybe the loss isn't that big. Second aspect that we heard is there shouldn't be any hierarchy. Professor Dojani mentioned that by quoting the I think European Court of Human Rights with regard to the interplay of the various guardians of fundamental rights in Europe. And I do agree, and I do see a strong linkage to the talk of Professor Varga, arguing that his fear, if I'm right, is the absolutist tendency in an emerging system. And again, I can agree, but I think for me, that's the key question that all our assemblies have been about and we are revolving around currently. What can we do to prevent such an absolutist tendency? And many people have addressed that, I think, in history, and maybe much of our legal civilization can be read as a response to that. I think separation of powers, the system of checks and balances, is one idea of doing that. There is, you mentioned the dualism between a religious and a secular authority. This has been, I think, elaborated craftfully by a legal historian from Italy, Paolo Prodi, 20 years back in Una Storia della Giustizia. He was quite sober in his assessment that it's gone. The role of the religious authority as a check on power, a functioning check on secular power is probably no longer there. And last point I'd like to emphasize in this regard, Joseph Weiler, also quoted earlier this morning, has forcefully, I think, interpreted the project of supranationalism as exactly this kind of dualism between nationalism and mind, and remember also nationalist absolutist tendencies are dangerous. So couldn't we positively interpret supranationalism as this desirable check, as a re-establishment of dualism to avoid the kind of fear that you're concerned about? Thanks.
the problem is that all lie, because it is impossible to be partly a state and to be partly supranational. We should decide that what we want, yes?
That's absolutist, isn't it?
Counter-provocative question, but I think that we can answer during the lunch. My question is that do we think really that separation of powers within the European Union is so strong and so concrete and so efficient than it is in its member states or in any state from United States to our region? Because I don't see this very, very strong institutional separation. And I'm afraid that even if we think that there is some kind of separation, the role of member states is out of this architecture of separation of powers. That within the European Union, within the legal order of the European Union, we may have the legislation separated from the executive. If I look from very far and I take down my glasses, then I see something. What we see a bit stronger is the separation of the judiciary. But where are the member states? Will the independent judiciary within the European Union protect the will of member states? Do we think so? So this is the question, and I think that we can speak about this during the lunch. Yeah. Thank you.
Just, I think this question should be understood. Perhaps, well, I would propose to understand this in a quite a different way, because the human rights and human rights protection and human rights case law, etc., it is focused on the affirmation of individualistic approach to human beings, so to make human being more and more autonomous. And the protection of human rights, it means in fact, yes. So perhaps we should ask a question: do we need people to be more and more autonomous? Do we need social structure to be more and more weakened and dismantled? Perhaps this is the perspective which is also important when we are asking about human rights, because human rights it's very nice expression, yes, but if we go deeper in the analysis of what does it mean, the protection of human rights, it appears that human rights should be protected oftentimes at the expense of social order, of social structures, of social values, etc., etc. So we should remember that when we are speaking about the protection and better protection of human rights, we are in fact speaking about the weakening of society and social structure. This is my comment.
I'm Giacinto della Cananea, University Bocconi, Milan, Italy. And this was a fascinating session. I'd like to make comments and ask questions to all the speakers. Only for reasons of time, I will confine myself to a short comment and a question to Dr. Senalek, who introduced this session. Now, one short comment on the descriptive or empirical side, and one question concerning the normative side, which you have emphasized with clarity and which raises some interesting issues. Now, the quick comment is the following one. At the beginning of your presentation, you said that the member states are often unwilling to leave room for the intervention of the European Union. And I agree with you. We can make plenty of examples concerning, for example, taxation. But isn't it true at the same time that there are other areas in which the member states ask the European Union to step in? Just two quick examples. One is the fight against terrorism. After the resolutions taken by the Security Council, individual member states could have acted alone, but even the UK preferred the joint action by the European Union. And what about the pandemics? The joint action to buy vaccines and distribute them. So I was wondering whether in the finalization of your paper, it could be interesting to try to give an answer as to why sometimes the member states are unwilling, while in other cases they are more willing to concede. And then there's the question concerning the normative side. Now, you made a strong case in favor of diversity, and I have to confess that I have much sympathy for it. Yet at the same time, you have used for your presentation some arguments, for example, the basic norm concerning directives for unification. And I was wondering, since you said that you are a new lawyer, how would you interpret the old dictum of the Treaty of Rome, which is still part of the Treaty on the European Union, that the treaty lays the foundations for an ever closer union between the peoples of Europe? Because in my view, it can be interpreted in more than one way. There is not only one interpretation, but since it is part of the relevant constitutional principles which we are bound to interpret, I would be interested in listening to your interpretation.
Well, thank you very much for your reaction. And by the way, it was great planning from the organizers of this session, since Professor Štepkovský was following on me, since he touched certain topics which I would like to target as well, but I simply didn't have enough time. And he touched that part which I was simply just referring to as the social evolution. And if I was on his place, I probably wouldn't work with the French reality, and that's because I don't speak French. I can barely read, but I'm more familiar with German reality and German evolution of law, starting with, I would probably cite Savigny and his approach to the evolution of state and law, and probably the Volksgeist is the term which is crucial here, since you were referring to modern state and its role, and the question is whether we do have here something like this, a certain independent power trying to do the promotion of unity, as it happened in France, where this was the situation. But then I was thinking that perhaps a question may appear in which areas the uniform rules are beneficial for the European Union. Since I was saying that I believe that in certain areas uniformity is necessary. Well, and I was thinking, and it was not enough time to deep for any deep analysis, but I think that there are two areas. The first area is those areas where member states face common threats. So it's all. I would say that the uniformity is necessary in all cases where security of member states is touched. And you have perfectly named one example. I would probably think about the external security of member states of the European Union, which is quite surprising, since that's where we don't have this unity so far, obviously for political and internal security reasons of states. And that's probably what was addressed by a different group led by Professor Zsombori. Well, and then the other area where I believe the uniformity makes sense is, and you have touched it, it's where there is a very strong cross-border element. And we have it in case of goods, and there is a strong need for standardization. When I was a young lawyer at a law office, since I was the youngest there, my task was to prepare an analysis of new legislation, which was somehow crucial for our top clients, and it was provided as an information for them for free, as a sort of a service we were providing them. And I was able to do that just for the Czech legal order. But some of them had, business overreaching the Czech territory. They were doing business in Slovakia and other states, and I couldn't see that. Here, the unification really makes sense, and it was the business who was in the beginning who was asking for unification. But there are many other areas where the European Union currently is trying to step in and unify rules, and I don't believe that that's really necessary. And you know, if we generalize it, the same thing happens also with the European Court of Human Rights and its interventions into the standards of human rights protections that are in certain states perceived differently because of different constitutional identities and values we rely on. And well, the other question, the ever closer union, that's a fascinating question. And I would love to know how to interpret that piece of preamble of Treaty of Rome, since there are two possibilities how to approach this sentence. The first one is that we have a certain goal where we are heading to. And the second is that the goal hasn't been defined yet, but we have specified just the process, how to achieve, but the final destination is somewhere. It seems to me that currently we are using it as currently it serves as this regulation of a process without any clear specification of the final destination. Yes, yes. And I would like to see where the destination is. We have to, you know, and probably it's what my colleague was speaking about. Probably it might be the modern state. The European Union may transfer in a state, but we don't know it. It's not written there, and we don't have any interpretation. And I would be glad if you could, you know, help me with that, since that's one thing which really interests me. So thank you. Thank you for your questions.
I completely agree with that. The concept that the deciding power was moving from the local communities, from feudal structures, passing through the national parliaments, and coming at the end now to the European Parliament that has much more competencies that they are raising. But on the other hand, there is another feature of the European Union that I find confusing and maybe contradictory. It is that the European Union stimulates and supports the establishment of euro regions. Because I was mentioning Spain last time when we had this kind of conference, that in Spain there are these double identities. And also for this example, we have euro region Galicia, North Portugal. We have also euro region Euskadi, like Baskia, Novara, New Aquitania, that's in France. Or also Catalonia and that Occitan region in France. So the thing is that the creation of this euro region was not justified solely by economic reasons, but also by linguistical and cultural, because people who are living in these areas, they belong or to the same culture or to the cultures that are like brothers, that are very, very similar. And then at the end, we come to the final consequence that the European Union promotes the solidification of these regional identities. I don't want to say national because that is contrary to the Spanish constitutional law. Maybe that was not the final intention of the European Union, but the consequence is that people do not abandon their traditional identity, but strengthen what they already have. How do you interpret this tendency of the European Union? Is it just an exception, or maybe in the future it is going to get stronger and stronger?
My opinion is by no means accidental, that this process of integration should weaken all those modern barriers and modern frontiers, etc. And one means of doing this is to support all those peculiarities, distinctiveness which is crossing the borders of the modern states. And in my opinion, it is very purposive approach, political approach taken to weaken national identity for the promoting some regional identities, which are sometimes just protected and sometimes reconstructed from almost non-existence or some residual existence, but some finances are often offered to make it to reconstruct them. So this is the part of this process. I have no doubt in this perspective.
Thank you. In my view, I don't see some great plan behind these processes in the European Union, because you had a couple of examples mainly from Western Europe, but they are not doing the same in Eastern Europe. Last time we were talking about these two, that all those culturally different groups, they focus on some of them, but they don't focus on, for example, the, I don't know, Inuit groups in Northern Europe, and they don't really have a long-term vision on the immigrant people either. So even establishing these kind of regions is not a general idea for the whole European Union. And if we are talking about the process of ever closer union, I see that it's focusing on much more on power reconstruction, allocation, than on the consequences on society, so the societal and cultural level. And by this, it's just a half-flagged entity. Thank you.
One more comment. If there would be no plan behind, then the money wouldn't be spent for those undertakings.
I would say it's an ad hoc plan.
Well, I think it is quite. The strategy is quite similar to in other perspective. Yeah? So now, within the social perspective, we've got very visible, well visible policy towards removing sexual identity from the socially important factors. Yes, we are going to construct society where division between men and women is not at all important in social structures. Yes, we need individuals and not men, women. Yes, so we are going towards the model where marriage is a union of two or more persons, individuals, etc., but not necessarily men and women. So we would like to make this difference between men and women unimportant at all in social life. And what is the way to do it? Is to affirm different sexual identities, 50 or more, because if we start to affirm 50 different sexual identities, then the really sexual identity lose any importance for social life. It is so many of those identities that it is unimportant because you cannot manage this. Yes, if you've got two sexual identities, male and female, it works. Yes, if you've got 50, it doesn't work at all. Yes, so it is completely unimportant. So this removing of national identity through the multiplication of some regional identities is a very good strategy to achieve this overall unified European identity.
I know it's late, and I know that most of you are tired, but I cannot resist to the temptation to make a quick gloss to the presentation made by Alexander. Now, you will remember that in Voltaire's Candide, there's a German professor of philosophy who says that everything goes for the best because we live in the best of all possible worlds. So he's beaten, he's abused, he's almost killed, but he continues to say that since we live in the best of all possible worlds, everything goes for the best. Now, fortunately, Alexander is very different from that professor of philosophy. Yeah, you're a lawyer. Now, and interestingly, you said, so I will concentrate my comments on one specific point, the clashes. So you said that for most, or for many European Union lawyers and public lawyers more generally, there are no problems because we live in a world where there are so many charters of rights, so many judges, that why should we bother? The point you made, there are some problems which should be handled, is a very reasonable point. And I basically agree with you. There's only a little gloss that I would like to add as a comment for our dialectic interaction. What about a pluralist perspective? So if we accept that we have several charters, several judges, several possible interpretations, some of those problems which you mentioned, the clashes, will have to be considered. But shouldn't we be aware that from a pluralist perspective, there is inevitably a dimension of disaccord and conflict? So I would like to suggest and ask whether the clashes which you have identified, and most of them are problems which can be not only identified but also solved, but whether there is a certain quota of those problems which is simply in the nature of a pluralist system, and there's nothing to do. Not because those are not problems, but because we have to accept that unlike in a system with a single Cour de Cassation and a single constitutional charter, we have to survive, notwithstanding those problems. That's it.
I agree, basically. But still have to elaborate, obviously. Sorry for that. I do think that there will be unresolvable conflicts, and I do think that we should be able to live with them. And I do think that the European Union in its past with regard to the management of fundamental rights disagreement or cases of disagreement in the area of fundamental rights has done a relatively good job. My concern is with the concern of commentators, basically. My sense is exactly your analysis I fully share. My impression is that this whole area is taken very seriously, and I think if everybody were to take it with the kind of relaxation that seemed to be your attitude, that I'd be entirely fine with that. And to give it like a brief kind of cultural contextualization, probably 5 years back, I wouldn't have been so concerned about that. My trust in the German Constitutional Court and its relaxation is gone. Probably we have a good basis to assume that they're out of the business for a long time now, and we'll see. But I mean, for 40 years, they managed to be really relaxed on this pluralist coexistence matters. And all the German scholarship was really focused on potential questions of who's the final arbiter and shouldn't we solve and do we need the Kelsian kind of closure to the system and all that. And ultimately the court gave into that and caused a major crisis for a relatively minor issue. They failed, by the way, to address the much bigger issue later because they couldn't anymore. And now for the fundamental rights regime, the German approach, again, if it hadn't been for this traumatic experience, I'd say, well, they're exactly on the Solange lines again, and we can just live with pluralism. So I agree. My concern with the concern is probably because of the recent experiences in Germany.
So I'll be using the term federal or federal-like. I really liked your example with public procurement. It was a really good one, but I think that there is one thing that has to be taken into the account.
Sure.
And when it comes to public procurement, the main difference between the European Union and United States lies in a significantly different material sources of law in the United States and in European Union. The issue is related to the mischief, the regulation in the United States and public procurement directives in European Union were set to resolve. In the European Union, the public procurement was traditionally strongly linked with state, the national state and its companies, and close to other companies from other states of the European Union. So there was a strong need for a strong external impetus to change it, whereas I believe in the United States there was no such need, since it was just one state, and this discrimination was not as omnipresent as within the European Union, within the European region. Without this uniform legislation, I'm convinced that national standards within the European Union would really quickly return back to the normal. So actually, I believe that this example actually proves that European Union is less federal-like entity than United States, despite the existence of more federal-like legislation. So that's it.
Good, thank you. Shall I respond immediately, or do you want to take on other questions? Good. Oh, thank you so much. That's a very good point. And I knew when I decided to use that example that it could be viewed in the other way, because one could make the argument, but if within the United States there is not a uniform and centralized legal framework, why should we have it within the European Union? I'm totally aware of that. What is interesting is, however, that there is not only the goal which you mentioned, so the necessity to open up markets, but there is also another element, that is to say, especially in continental Europe, within many legal systems, there's a sort of suspect vis-à-vis the administration. So we are concerned that the administration may act arbitrarily, while in the United States, the general idea is that we give you powers and money. You use powers, you use money, and then we see at the end of the day what is the outcome. Interestingly, you have mentioned the issue of the regulation, which should be viewed in more than one way. First of all, there has been, but that is about the federal power. After Reagan, there has been a consistent use of the powers of the executive branch in order to avoid legislation. But remember that what I was considering is not so much the federal level, which would be the equivalent of the government procurements of the European Union today, but I was interested in how the states are organized. And interestingly, in that respect, sometimes they use the executive branch powers, while in other in other states, especially the big ones, they prefer to use legislation for a number of reasons. So let us say that the whole point is not only about the underlying reasons. So why do we want to have a legal framework? But it is which are the legal effects of that legal framework. And as you know, because you are an EU lawyer, there is plenty of cases of the European Court of Justice discussing, for example, whether Italian or German local authorities unreasonably deviated from the rules governing public procurements. Of course, one could make the argument that those rules are too strict, they should be relaxed, they should be more flexible, and that is a totally acceptable argument. The legge ferenda. The legge ferenda. The legge lata, as you know better than I do, probably, those rules are binding. And so the idea that you can have a no-bid public procurement would be declared annullable by all ordinary or administrative judges. So it doesn't matter so much whether we have one system of judicial review or another. But could I take the point that you made, because I'm really grateful to you for picking up that example. What about the public procurements of the European Union itself? There's one interesting point which has stricken my attention, and it is that while the European Union is very demanding with regard to transparency for national public procurements, they are, so to say, using a sort of double standard with regard to the public procurements of the European Union. So one could make the argument, if transparency is so important, and everybody may understand why transparency in itself, it is a value in itself, it is indirectly relevant if we want to preserve the rule of law and so on, why do you have a less demanding standard of transparency for the public procurements of the European Union? Now, even an administrative lawyer in that respect may raise the doubt that the Union is not fully coherent, so to say, with its premises. Because if the premise is transparency matters, well, it should matter everywhere. Thank you.
First, for Marietta, I found this really intriguing to notice that Article 4, subsection 2, will open up, and sooner or later it certainly will, a lot of new questions. To explain my limited vision as a German, there has been so much of a constitutional identity as a core topic in the German constitution and in its dealings with the court's dealings with European integration that all predates this provision, right? So from my limited perspective, I always thought, so Article 4.2 is about respecting what has been there already. And I didn't even think of any dynamic interplay between the two. And your presentation, I think, raises a lot of very interesting questions with regard to that. First thing, I just revisited the provision, and it somehow reads as if it were about granting respect to the pre-existing, but not necessarily so. And now the questions that I think arise from that is, what is national or constitutional identities in this context? It's somewhat ambiguous how it's framed there, right? Is identities something you choose, or is identities something that you take up as a pre-existing given, which will, for that very reason, be respected? So, very specifically, can any of the European member states say, well, this is the moment for a reboot, a big overhaul, we reconsider, modernize, etc., our core identity, or these principles that we want to be sacrosanct against European intervention? we'll redefine in a very democratic fashion, and we ask you, dear EU, to respect that. Or, and if doing so, should there be any interaction between supranational and national level in that? Or is it something that can only, is this the reference to the, whether existing or not, sociological a priori that we have? So yeah, only questions, but I think it's intriguing because not just Germans are limited in that, I guess, but particularly so, but even the text of the treaty seems to be not considering this long-term dynamic interplay that's possible there. That's well, thank you.
Thank you so much for your comment. It looks, yes, that the discussions between courts indeed raise a lot of questions in terms of dynamics of the core values of the Constitution. But from their interpretation, I think that all these values looks like fluid values somehow. Because as I try to emphasize in my presentation, it looks that these values are somehow reinterpreted in this dynamic of dialogue and in this dynamic of the European legal order. But it's most obvious in terms of the human rights and standards of human rights. I don't know, for example, when it comes about other values enshrined in the Constitution, how this approach will be. That's why I concluded somehow that the way in which we'll understand these values in the future depend of this common approach or this dialogue between the actors in European Union. The judges, in fact, from the perspective of my presentation. All of this is it's a kind of fluid and dynamic. Professor Toader mentioned in his presentation that sometimes in the argumentations appear that theory of living law, even when it comes about these values. I don't know. I don't have a very specific answer to your question. Finally, I also think, like Professor Cananea, that I don't know. We have to think out of the box and to try to understand this evolution, not to remain in, I don't know, in specific definitions of some values or some realities or some concepts. Now, a part of the question, I tried, for example, to have that events of dissemination in 2 states, which are federation, in Brazil and in India. And it was very interesting also the reaction of the professor and the students comparing our struggles here with their realities, because also Brazil and India, like federation, they are very, very different in terms of organization of the state. So yes, we have to rethink all these concepts somehow. So there remain a lot of questions and a lot of things to discuss on these struggles, let's say, in terms of find our own way here. Thank you so much.
Thank you so much. Now, as Alexander, I was very interested by the presentation made by Marietta. She gave us a presentation which showed, in my view, 2 important elements of identity. One is that it is an evolving concept, and the other, I would say, that it is a relational concept. It is evolving in the sense that even though we were to accept that national identity is mainly, but not only, shaped by history and tradition and so on, still it is not something immutable. So if a state, for example, decides not only to enter within the European Union, but also, for example, to become or to remain a member of the Council of Europe, there is an important element of its identity in the sense that it opens up its legal order through a dialogue with other legal systems and their courts. But what is perhaps more interesting, and I gathered that from Marietta's presentation, is the relational nature of identity, in the sense that your identity is not something which you would point out if you are alone, because if you are alone, you don't need to point out your identity. But when you enter into some kind of relationship with others, then you want to define your identity. And how do you do it? Now, from our research, our historical research on administrative laws, what emerged, for example, was that when Belgium obtained independence from the Netherlands in 1830, one of the first few things they did was to say, we don't want to have any Council of State with judicial powers, because that was an element of Dutch centralization, and that was a choice made by the French, the big neighbor on the other side of the border. So between 1830 and 1946, Belgium lived happily without administrative courts. But what happened later? It happened that during the Second World War, there were not only errors and horrors perpetrated by other military troops, but there were errors and horrors perpetrated by some Belgian governors. So they decided in 1946 to give judicial powers to the Council of State. So if that had been an element of the Belgian constitutional identity for a long period of time, more than a century, since the beginning, then they understood that if you want to have a more civilized administration, you need to have some competent persons dealing with at least certain types of dispute. That is not an argument to say that the Belgian Council of State is the same thing as the French. There are huge differences. But they understood that their constitutional identity had to be adapted to new realities. And I think that the point which has been made so clearly by Marietta about the need to consider human rights, not only from an exclusively national perspective, but from a broader perspective, including, for example, not only fully fledged courts, but also the work of the Venice Commission, for example. It's quite interesting because if you look at the reports, they're not judgments of the Venice Commission. They always begin with an accurate analysis of comparative law, and they continue with an analysis of the case law of the European Court of Human Rights, and sometimes also of foreign higher courts. So I very much agree with her. The question that arises is whether the different national clauses concerning human dignity have been interpreted in a different relational manner. That would be in itself an interesting focus for a deep comparative analysis.
Because in the treaties, in the institution is national identity. In the constitution, it is constitutional identity. Could you tell me how do you see these problems, these items, this institution? Because national identity is the problem of sociology, but constitutional identity is the problem of law. They are different institutions, they are the same institution. And what is the same? Who should define it? Because it is in the treaties, and here competences has European Court of Justice. And when Constitutional Tribunal judge about constitutional identity, there is competences of Constitutional Tribunal. And what what should we do with this problem? Oh. This, I don't know who is.
Marietta first.
Okay.
Because she's the constitutional expert. I don't know.
Okay. So it's very important, but a very difficult question, you know. Yes, because your question reminds me about a meeting at the Constitutional Court, a visit of the President of European Court of Justice at the Constitutional Court of Romania. All the details is on the website of the Constitutional Court, so there are public discussions. And in fact, the idea is, I know that this word dialogue is, is used all the time, but the idea of defining this identity means, at the end, a dialogue between European Court of Justice. Yes, I know, yes, there are not the same institution, but we have to find a common point of understanding. So from the part of European Court of Justice, the invitation was asked us if you find something which is related with the question about identity, the better way is to ask also European Court of Justice to find a common meaning in terms of these concepts, because we have a concept in the treaties, we have some concepts, but in fact, at the national level, we don't have expressly mentioned in the Constitution national identity or constitutional identity. Yeah. Yes, I understand your perspective. Yes, I understand your perspective. But yes, but since we don't have in the Constitution this express meaning, and also as Professor Cananea said, these questions appeared in time. What is the constitutional identity? Because before our states became member states of the European Union, we didn't have this kind of question in constitutional review, for example. When the Constitutional Court reviewed the amendment of the Constitution, this question didn't arise. Even in these days, we didn't have such kind of question. The concept of constitutional identity was developed in other cases concerning the relation with European Union law. Yes, I think that it's not possible to be very separate in terms of defining this concept only at the national level or only at European Union level. Because we risk to, I don't know, to understand different words, different meanings. This is my perspective. Thank you.
Very well. I make only two additional comments. One is a comment on which I think that more or less everybody in this room might agree. That is to say that concepts are important and they should be used consistently. So, for example, one thing that I always criticized is that the treaty establishing the European Union qualifies respect for the rule of law and fundamental rights as principles and as values. Now, that is something that is not so much consistent. The second claim that I want to do is something on which every European Union lawyer might easily agree. That is to say, since the Treaty of Rome, the European Court of Justice is competent to pronounce on the interpretation and application of the treaties. That is old Article 164 of the Treaty of Rome, and it's the same today. So the consequence which follows from that, logically, is that the court is competent to interpret the concepts which are used by the treaties. If that is correct, there's a further consequence. I'm using a sort of syllogism. I'm an old fan of Aristotle's logic. That is to say that if the treaty uses the concept of national identity, which we as theorists we may criticize, because we may say, as you just said, it is more sociological than legal, but still, if it is a concept which is used by the treaty, then the European Court of Justice has competence to interpret that concept. You agree? There's a further element.
Every state, yes.
Yes, there's a further element, however. Since I'm in favor, as I said yesterday, of a moderate pluralism, I would add that if a national court sends a preliminary reference question to the ECJ, which is not a merely abstract possibility.
This is not the level national court, this is the level constitutional court.
Yes, yes, but what may happen, and you are certainly familiar with two cases which began in Italy and then were discussed everywhere, that is to say Taricco 1 and Taricco 2, concerning, by the way, the problem which our Romanian colleague discussed, that is to say, criminal procedure and the possibility to say that after a certain amount of time a criminal investigation should come to an end. So you could have, and this is not just theory, a constitutional court which raises an issue saying, for us in Italy or Romania, this is an element of our constitutional identity. Now, there are two possible interpretations, maybe more, but let us say that there are two possible interpretations. One would be coherent and consistent with our idea of constitutional identity. The other wouldn't be. How would you, the Court of Justice in Luxembourg, interpret? Now, all the reasoning I did until this point, I think can and perhaps should be shared by all EU lawyers. The last point could be questionable because we may have different points of view about the duties of national constitutional courts. But Marietta and I would say that within our legal systems, not necessarily in others, the courts have accepted to engage in a discussion. Now, is it right? Is it wrong? That is for Lila to decide.
I absolutely agree with your remarks concerning the autonomous interpretation of the European Union law. But I also believe that we have two types of terms and institutes within the treaties. Ones which, and those are the majority, ones which have a static nature, and those are interpreted solely by the Court of Justice, and it has the power to define what's the law within the European Union. But then we have a different group, way smaller, where the interpretation is interdependent, where member states also participate on the definition of these terms. And those are, and the one with national identity is probably not the best example. I would use something different from the area of free movement of goods. We have this rule prohibiting any obstacles and measures having equivalent effect in Article 34. And then we have Article 36, which contains a list of exemptions. And one of them is public morality. Well, and I believe that cases Congate and Hen and Darby from Great Britain, the old cases, confirm it, that these terms are, when it comes to this term, the public morality, when it comes to its boundaries, this is specified by the Court of Justice. That's its power. But the content might be uploaded by member states, and if it falls within these boundaries, then this term has is possible, such interpretation, and is applicable to that particular state, but not to the other member states where they have uploaded or they didn't upload any meaning. So it's these are very specific terms, and the national identity is something very similar. So both participate. The Court of Justice has the final say here in this respect, sets the boundaries, and the one who upload the substance are member states.
A very quick reaction, because I fundamentally agree with you. And I love to discuss with you lawyers because we discuss about norms and realities at the same time, not only about abstract ideas. Now, you are certainly aware that the other treaty upon which the European Union is founded, that is to say, the Treaty on the Functioning of the European Union, regulates that innovative and complex area which is called the area of security, liberty, and justice. And interestingly, in that area, the treaty says, the treaty establishes that there are both common standards and national traditions. Now, interestingly, yesterday during the discussion, someone mentioned Article 6 of the Treaty on the European Union, because that article not only makes a reference to the European Convention and the Charter of Fundamental Rights, but also says that fundamental rights as they result from national constitutional traditions. So one could make the argument that it is for national courts to define what is a national tradition, which comes to the argument made by Marcus, but one could also argue that it is for the Court of Justice to define the concept of national tradition, because otherwise you could not interact with different players at national level, which simply shows that what we are discussing is a set of concepts which cannot be said to belong exclusively to one level, but should be seen, as Marietta suggested, from a relational point of view.
But this is not a problem where this is on the level national courts. They ask and they judge. But the problem is on the level constitutional court, because constitutional court in Poland don't use European law as a basis for judgment, but judge if, for example, if a European law, for example, as a provision of the treaty, is constitutional or unconstitutional. Constitutional court in Poland don't use that, only judge it. This is the problem. We can ask, we can have answer, and we judge answer is constitutional or not constitutional.
Yes, just a short comment concerning the methodology of using the European Union law in the case of Romanian court, because it's related with your comment as well. Sometimes this European Union law is used because the Constitutional Court found that it is relevant to understand better some concepts, but from the European Union law. So that's why we have, for example, our preliminary, there is only one preliminary question of the Romanian court to European Court of Justice. In a case, it's well known, it's common case, concerning the marriages between the same-sex couples. But in that question, the relevance in terms of European Union law was a directive on free movement. That's why, related with the Charter. And that's why the Constitutional Court asked the European Court of Justice, what does it mean spouse in terms of directive of free movement? It is also what my intervention and I would like to emphasize that the control of the constitutionality concern the is the classical one. Yes, to find the constitutionality or unconstitutionality of the laws at the national level with the constitution. But sometimes some European Union acts are relevant in terms of constitutional review, like in this case. That's why there are also cases where this issue, and the needs of preliminary questions appears. Yes.
Something is unconstitutional because it's contrary to the European directive. And that this is
It's not this direct effect of the directive, because it was emphasized at the end, at the beginning of the presentation, that it's a kind of interposed in the argumentation and the reasoning of the Constitutional Court. Because usually it is about a law which transposes a directive, so we have a case law on that directive, case law of European Court of Justice, and that's why
to define constitutional items by consent of by context of.
Yes, it's put in the context of European Union law as well, because in that specific law, it is about some concepts from the directive, transposition of directive and so on, but it's not a control of constitutionality based on the directive, no. It is, maybe directive appear obiter dictum in the reasoning. It is, I don't know, we can discuss, it is good or is not good, but is not a direct effect of the directive, the unconstitutionality of the legal norms. It's the effect of the Constitution. It's a matter of argumentation of the court. We can discuss about this if it's good or not good. Or
if I may add just one or two words in this respect, confirming once again what Marietta just said. Also in Italy, it is a settled matter of constitutional interpretation that constitutional adjudication from a general perspective is not based only on what formally constitutional provisions establish, but there are several cases in which the Constitutional Court will have, not only will, but will have to use other norms. One of these cases, this is a very technical issue, and it may not be of interest for the majority of you, but is about the budgetary issues. Because when the court has to settle a dispute concerning budgetary principles, they generally have to refer to budgetary legislation, which is ordinary legislation, but which is relevant for interpreting the meaning of general principles such as the financial balance. How do you define the financial balance? No constitution can do it in all possible cases, not even the German Grundgesetz, where they have that wonderful or questionable provision concerning the balance, the idea of balancing. And once again, there's a strong similarity between Romania and Italy. I am not talking about Poland, of course, because European Union directives and regulations are often used by the court as intermediate legislation to arrive at a decision concerning the constitutionality of ordinary legislation. So that's a technique of interpretation which is settled. But as she just said, that doesn't mean that the EU regulation alone is the tertium comparationis, but it is an element of the tertium comparationis.
And indeed, just 1 minute, because you inspired me. Yes, we have the same examples, like your professor said about the budgetary laws. We have the same example with the norm of legislative technique. Usually the Constitutional Court, when decide on the legal certainty and the clarity of the norms, use some concepts from the law on legislative techniques. So, but you can say that the law is unconstitutional compared with the law of legislative techniques. It's
Marietta,
also
this is a wonderful duetto.
Yeah.
We could continue and go in other universities.